hearing of the Public Accountability Committee's inquiry into the integrity, efficiency and value for money of New South Wales Government grant programs. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of this land. I'd also like to pay respect to the elders of the Eora Nation, past, present and emerging, and extend that respect to other First Nations people present. Today's hearing will focus on local council government grant programs. We'll hear today from the Independent Commission Against Corruption, the Auditor-General and the Department of Regional New South Wales. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. I'll note that I'm serving today as acting chair, as we're joined by the chair of the committee via WebEx, David Shoebridge, and other committee members are either present or joining us shortly. Parliament House is now open to the public. All visitors, including witnesses, are reminded they must register their attendance in the building via the New South Wales app. Please see the Secretariat if you need assistance with this, and please remember to maintain appropriate physical distancing. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. I do remind everyone here today that committee members are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. I therefore request that witnesses focus on the issues raised by the inquiry's terms of reference and avoid naming individuals unnecessarily. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised they can take a question on notice and provide an answer within 21 days. I now welcome our first witness, Peter Hall QC, Chief Commissioner of the Independent Commission Against Corruption. Could you please state your name and position, title and swear an oath or affirmation?
Full name is Peter Michael Hall, presently Chief Commissioner of the Independent Commission Against Corruption. Thank you for your invitation. Members.
Okay, and would you like to swear either an oath or an affirmation?
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Chief Commissioner. Would you like to start by making a short opening statement?
Thank you, Chair. I would like to make an opening statement. If the members of the committee would bear with me, it might take 5 minutes or so. There are some important issues in this inquiry, of course, and accordingly this statement is directed to some of those issues. In this opening statement I will deal with issues concerning integrity in relation to grant funding. The Commission's written submissions in this inquiry cover a number of other matters, including compliance and evaluation of programs and grant applications. Paragraph 1 of the terms of reference, amongst other issues, raises for inquiry by the Public Accountability Committee issues concerning the integrity of New South Wales grant programs or grant schemes. The particular issue raised in paragraph 1B of the terms of reference addresses an issue concerning the integrity of funding, namely the scope of ministers' discretion in determining which projects are approved. Further issue raised by paragraph 1C of the terms of reference concern, I quote, measures necessary to ensure the integrity of grant schemes and public confidence in the allocation of public money, end quote. Terms of reference to which I've referred require consideration, in my view, of two matters. Namely, firstly, the extent of ministerial power, including in particular ministerial discretion, in relation to determining outcomes or approvals of projects for which grant funding has been sought. Secondly, the legal bases upon which the exercise of such ministerial power or discretion may contravene integrity principles associated with public office holding. Further, that could constitute corrupt conduct within the meaning of that expression as enacted in the Independent Commission Against Corruption Act 1988. In relation to grant projects generally, in addressing these two matters, it is necessary at the outset to say that there are, as observed in the Commission's written submissions, a range of grant programs or schemes. That being the case, the nature and terms upon which such programs have been established assume importance. In general terms, many, if not most, funding programs or schemes are established or founded upon well-accepted principles or standards, and these include processes for the transparent, fair and objective conduct and determination of applications in respect to such programs. Such principles are discussed in the Good Practice Guide to Grants Administration formulated by the Department of Premier and Cabinet, Good Practice Guide to Grants Administration 2010-16 as updated in accordance with Circular 2010 number 16. Once a funding program has been created or established by direction of the Department of Government, including the formulation of the conditions upon which it is based, and it is then activated by the appointment of persons to undertake the assessment of public calls for applications and the subsequent selection process itself, the funding program then becomes an established government-sanctioned administrative system in which members of the public, the applicants, participate. On the subject of ministerial power, whilst ministerial power, including discretionary power, may be exercised within a broad scope, it is not without limitation or constraint. Obligations in the exercise of a discretionary power may arise from the public office itself that is held, from the particular power that's sought to be exercised, or from legislation. Whatever its source, the principal obligation or requirement is that the exercise of the power should be for a public interest purpose. Without detailing all the limitations and the constraints on ministerial power, the following may be noted. Firstly, standards in relation to public power are sourced in principles that protect and enhance the public interest. Such principles provide the benchmarks of integrity in both the conduct of public officials, including ministers of the Crown, and in the systems and processes utilised by government and public administration. Secondly, the overarching principle that attaches to public office holding and for which other principles are derived, the public trust principle, expresses the values as well as the conditions upon which power is conferred upon public officials, both those appointed and those elected alike. The significance of that public trust is addressed in the Commission's written submissions to this inquiry. The third point is that a fundamental principle is, and I quote, institutions of government and the officials and agencies of government exist to serve the interests of the public. And I quote from the WA Inc. Royal Commission report, the footnote reference, Chapter 1, Part 2. Next point, the exercise of ministerial power in accordance with the principles that inform the exercise of public power must be undertaken honestly. It must be exercised properly in the public interest, and not improperly for reasons or purposes that are extraneous to the public interest or to the purpose for which the power exists. Turn to the issue briefly in relation to the subject of ministerial intervention in relation to grant funding. Whilst every case necessarily turns on its own factual circumstances, if a minister intervenes and overrides a government grant program or scheme, including in particular in relation to the decision-making processes by which successful applications are determined, and intentionally does so for purposes of possible electoral advantage, such intervention could constitute corrupt conduct under the provisions of the ICAC Act. In a case where the relevant minister intervenes with the selection process with an intention of benefiting persons or entities for electoral advantage, and who or which are not selected as the successful candidates, then significant questions, including questions of law, arise. If it was asserted by a minister or other public official that such an intervention by a minister constituted a proper exercise of discretionary power, then in that case two matters would arise. First is that any such contention wrongly assumes that as a matter of discretion, ministerial power can effectively negate or rewrite the terms and or the conditions or the operations of a duly established administrative system or a grant program of the kind referred to in the Good Practice Guide to Grants Administration Guidelines. Secondly, the principles concerning the mental element associated with the offence of misconduct in public office would need to be carefully assessed and applied. In accordance with those principles concerning what is termed the state of mind of the public official, including, I note, the principles that were discussed by the New South Wales Court of Appeal in Maitland against the Crown and McDonald against the Crown, 2019, New South Wales Court of Criminal Appeal 32, the intention or purpose of a public official, if accused of an offence of misconduct in public office, would need to be established. In particular, it would need to be established that the power or discretion was intentionally exercised for an improper or illegitimate purpose. In relation to the hypothetical case to which I've referred, of a minister intervening in a grant program so as to alter its outcome, and at the time of intervening there was a combination of motives or purposes for the action of the minister or other public official, what might be referred to, and sometimes is, a mixed motives case, the relevant test to be applied is a test of causation. Whether any impermissible or illegitimate purpose was causative in the sense that but for its presence, the power would not have been exercised. This may be referred to, and often is, as the but-for test, to be applied in relation to a mixed motives case. If an extraneous benefit to be derived by the exercises of the minister who sought to intervene in the selection process, in the example I've referred to, consisted of the prospect of obtaining an electoral advantage, then notwithstanding the existence of any other motive or purpose, that in itself could be sufficient to satisfy the but-for test in determining an issue of corrupt conduct under the ICAC Act. The circumstances of each case, of course, would need to be fully examined. I note in respect of the Commission's role in all of this two things. Under Section 2, capital A of the ICAC Act, the principal object of the Act is stated to be the promotion of the integrity and accountability of public administration. Further, in exercising its functions, the Independent Commission Against Corruption is required by Section 12 of the ICAC Act to regard the protection of the public interest and the prevention of breaches of public trust as its paramount concerns. The Commission's jurisdiction, of course, is exercised over a very wide range of public officials, including a Minister of the Crown. See the definition of public official in Section 3(1) of the ICAC Act. In its written submissions to the inquiry, the Commission acknowledged the existence of a legitimate discretionary decision-making power in a Minister of the Crown to bring political considerations into account on matters of policy formulation. What, however, the Commission does not accept is a proposition that suggests or asserts that ministerial discretion is without limitation or constraint. There are constraints that arise from common law principles associated with public office. Dishonest or improper conduct of an elected official may constitute corrupt conduct. Improper conduct may be constituted by conduct that is in breach of the public trust. Improper conduct may also arise from conduct that is actuated or influenced by an extraneous or improper purpose or objective. Relevant states of mind of a public official associated with particular conduct, whether described as involving a purpose, objective, or an intention, are matters that are central in establishing whether the conduct is corrupt conduct under the Act. Power of a public official, including a Minister of the Crown, to authorise and to direct the use or application of public monies is a power of considerable significance. It is a power, of course, to be exercised appropriately. It is a power to be exercised with appropriate level of care. Power that should normally be exercised on a transparent and accountable basis. These last comments, I emphasise that the misuse or abuse of public power by a public official involving public monies, including grant funding for an improper purpose, can, in some circumstances, be corrupt. In the case of Scott and Martin in 1988, 14 New South Wales Law Reports 663, the Supreme Court, which was then sitting as the Court of Disputed Returns, in a case that involved an allegation of bribery and the provisions of Section 147 of the Parliamentary Electorates and Elections Act 1912, the Court, Justice Needham, observed, and I quote, unfortunately, modern times, there seems to be an accepted view that public monies are in the unrestricted gift of those in power. In some cases, the temptation is to use such resources for purposes of party political advantage, end quote, page 673. There is currently a level of concern in the community in relation to conduct alleged to involve what is often referred to as pork barrelling. Without embarking upon an examination of such conduct, it is appropriate to observe, however, that the Commission is aware of community concern in relation to such practices, including in particular concern in relation to certain instances of grant funding. In undertaking its investigations, the Commission does not rely solely upon complaints or notifications. Approximately 2 years ago, the Commission established a strategic intelligence unit within it. That unit enables the Commission to undertake intelligence assessment of corruption risk with a view to enhancing its proactive intelligence approach to its investigations and its own motion power under Section 20 of the Act. In conclusion, I have referred earlier to the Commission's paramount concerns, which are the protection of the public interest and the prevention of breaches of public trust. The community, I suggest, may have trust and confidence, at least in relation to one matter, and that is that the Commission has the capacity and it will do what is necessary to ensure integrity in funding, in particular in relation to program grants, or as necessary and in accordance with its established procedures, it will investigate alleged or suspected misconduct in relation to such grants. Thanks. Thank you for the committee listening to the opening statement.
Thank you, Chief Commissioner. That's been a lengthy opening statement, but I think helpful in the circumstances to set out the principles. That's very important guidance for the committee. I might ask that you provide that opening statement to Hansard for their assistance.
I do have a copy of that opening statement, which is available.
Thank you. I might commence just with a couple of opening questions before handing to my colleagues. You've particularly focused on the, well, firstly, you have provided us some real guidance on the principles that might apply. You've dealt with ministerial intervention and also in detail, also with ministerial discretion. One of the concerns with from some of the submissions we've had to the committee really relate to quite an extreme amount of ministerial discretion where there might be a recommendation but really it is then up to a Minister of the Crown just to choose which project suits, literally choosing perhaps on a spreadsheet. What issues might that present, and would that be of concern if that's the level of discretion that's applied?
Can I just clarify the point you wish me to respond to on the other submissions on ministerial discretion?
I'm just on the point of ministerial discretion, at the point where a minister is simply choosing which projects apply, perhaps from a just from a spreadsheet with quite an extreme level of discretion, what issues does that present?
Well, members of the committee, the variation in grant program schemes, of course, has already been noted. One would start with an examination of what is the legislative framework for the program in order to determine issues, in particular, issues of probity and fairness and objectivity in assessment. I observe that in many of these grant funding cases, those who apply spend a great deal of time and resources in formulating their applications. Some of them, of course, are not without great merit, but I think many, if not most, often do have considerable benefit. All the more reason why there should be integrity in the processes. The legislation should provide the framework which will support and reinforce in the process, and in particular in the selection decision-making process. So it would be my respectful suggestion that it is to the legislative framework that one would commence an examination. It would be, I think, extraordinary if legislation was framed in a way which provided for a Minister of the Crown to have a complete unfettered discretion to override the scheme itself. As I've said in my opening, established under legislation, normally it is a government-sanctioned administrative system. And unless there was an express power in the legislation to override and negate that, so that in effect you remove probity out of the system, and one can't even imagine that any legislature would entertain putting a reserve power of that kind in the legislation. Unless that extreme measure was taken, the principles to which I've referred are there. They must be respected and must be complied with. And if there are cases where there's intervention by a Minister of the Crown, for example, to skew a result or alter the result that's gone through a prescribed selection process, the ulterior motive being, for example, in a marginal electorate, to be able to enhance the prospects of electoral victory, then that, as I hope I've sought to make clear, could be an illegitimate use of the power. I use the word could advisedly because, as I've said, it depends on the facts and circumstances of every case. And that is why sometimes inquiries in the Commission do take time to establish what was the base for a decision taken. Did it comply with and proceed through accepted conventional processes? Or if it didn't, why didn't it? What were the circumstances that could justify a departure? All of this indicates, in my view, that there is an element of rigour in determining how public power is to be exercised. I hope, Chair,
that is helpful. I might turn to my colleague, the Honourable Natalie Ward.
Thank you, Chair. Thank you, Chief Commissioner Hall, for coming along and assisting the committee today. I have just a couple of questions. Although I suspect the majority of time will be taken by my friends. I thank you for your opening statement. I've listened to that with interest, and your references to integrity and public confidence. Of course, this committee...
just missing the odd word. Thank you.
Sorry, can you hear me now?
Yeah, it's better. Thank you.
Yes, good. I was interested in your opening statement and your references to integrity and public confidence and a number of matters raised there, and thank you for that. this committee, of course, is established to, by resolution, to inquire into and examine the public accountability and service delivery of New South Wales Government departments, statutory bodies or corporations. Because this committee and the House, and I'm asking you if you agree with this committee and the House places a premium on integrity by those entities and efficacy and value for money. Do you agree with that?
The point of your question...
The purpose of this committee?
Yes.
I'm trying to agree with your opening statement about integrity.
I understand the purpose and the noble objective, if I might respectfully say so.
And this committee and indeed this inquiry exists because public trust in the integrity and efficacy of public institutions is can't be, the importance of that can't be overstated. Would you agree with that?
Absolutely. I think that there has for many years been concern expressed, and I've followed it myself in the literature. Firstly, the absolute importance of trust and confidence in the institutions of government.
Thank you.
And
you'd say that would be critical, wouldn't you,
Absolutely critical.
to modern democracy? Okay, we're agreed on that.
I wholeheartedly agree, and that everything should be done to support trust and confidence. If trust and confidence gets out of hand and grows to a level where people do have doubts about either the personnel or the system or the processes of government, it fuels, of course, cynicism. Government depends upon the people to support it just as much as the people depend on the government to support it.
And when you talk about that, you talk about the integrity of the processes. I wanted to pick up on that point in particular. And I think you mentioned that extended to the power conferred on public officials, whether appointed or elected, in your opening statement. Is that correct? Did I hear that correctly? Yeah, thank you. In this regard, Commissioner, you'd be aware that there have been two quite shocking breaches of the Premier's privacy this week by the ICAC. Are you aware of those?
Could I just say that I don't wish to address any matter that might be in the media or otherwise.
Apologies,
my question goes to the efficacy of these public bodies.
I'm just going to take a point of order. Raised.
My point of order is in relation to the terms of reference and the question that was just asked. We are very clearly here with a broad-ranging terms of reference, but that does not cover the events of this week unless they can be related directly to the terms of reference around government grants. Then I don't believe that is within the purview of this.
I'll hear from you on the point of order.
To the point of order, Mr Chair.
I've already asked for the call.
I've got Natalie Ward, then David Shoebridge on the point of order.
To the point of order, the terms of reference which I referred to in my question referred to the government departments, statutory bodies or corporations. So that was the resolution of the House. The inquiry is convened to look into those issues, and in the opening statement, the witness opened the door by referring to integrity and public confidence and agreed with me that extended to public officials, whether appointed or elected. This body is here to talk about confidence and public integrity. I'd like to know from this body whether that body's public integrity and processes, which we're dealing with directly, I have questions surrounding that, and I think it's directly relevant to the terms of reference and to the witness's opening statement.
Mr David Shoebridge on the point of order.
Thanks, Mr Chair. Look, I think it's a tangential at best to our terms of reference, and I doubt the Chief Commissioner has come here today prepared to answer that question. But I think the question having been put, the Chief Commissioner, if he is in a position to provide an answer, it's open to the Chief Commissioner to provide an answer. And if he's not in a position to provide an answer, given I doubt it was part of what he prepared for today, then he could provide the answer, any answer he wishes to on notice. And I think that would be the appropriate way forward.
Right, any other views on the point of order? Otherwise, I will rule in this way. I have two concerns about this. One is that I do think this falls outside the terms of reference of the inquiry, noting the submissions you made, but given it is into the integrity, efficacy and value for money of New South Wales Government grant programs, I regard it is out of the terms of reference. Secondly, the question relates to a current investigation. I agree that, Chief Commissioner, if you'd like to put anything on the record, you're welcome to. You're certainly not obliged to. You have the call.
If I may.
Well,
if I may.
I have ruled on that question.
Well,
So,
you raised another issue which I'd just like to
Well, I
address,
have ruled
though,
on
about a
the-
current investigation. Point of order.
yep.
Chair, you raised the issue of a current investigation. I don't wish to in any way discuss the current investigation. I wouldn't invite the witness to comment on that at all. What I'm asking about is the efficacy of this institution, given that the witness opened the door. So I would like to address, and I press my ability to ask those questions, because it's an exercise of public power that the witness spoke about. He agreed that it's appointed or elected officials. He talked about integrity in the processes. It's what this committee is dealing with. I'd like to understand. I have two questions about that. And I press to ask those questions. I think that people want to hear. The witness is here and people would like to hear about it.
Right, thank you for that submission. I have ruled the point of order out of order in relation to the terms of reference, your original point of order. Chief Commissioner, you are welcome but not obliged to make any statement though in response.
I raised 2 points. Firstly, again, the sound system is not coming across here too clearly. If you could just formulate again for me exactly what it is that your question is directed to. Secondly, I have indicated that I do not wish to directly or indirectly deal with any specific matter that might be in the public domain, or perhaps that the Commission might be investigating. Improper for me to do so. I am, however, here to assist this committee in any way the Commission can, and I'm very willingly here to do that. Third point is that once I'm clear as to exactly what it is that's the question is directed to, it may be appropriate for me to take it on notice rather than deal with it today, but I'd perhaps reserve on that aspect.
All right, can I put it this way?
If you wouldn't mind just formulating again what the question is, I'd be grateful.
Mr Hall, you spoke in your opening statement. You asked the question, Commissioner Hall, in your opening statement.
Yes.
You spoke about the power conferred on public officials, whether appointed or elected. And you talked about the processes being very important and integrity in those processes. Do you agree with that statement?
I do. Yeah.
How is releasing the Premier's private mobile number and details of her personal residence proper processes when those matters were supposed to be redacted by the ICAC and were not? How can we have any confidence in those processes that you say you uphold and that the entity upholds when the Premier's mobile number and her private residence has been released?
I'm going to take a point of order.
How can we have confidence in your institution?
A point of order has been taken. I'll call the Honourable.
How can we have any...
The member is clearly flouting your ruling. We are here to discuss important matters about government grants, and the member is clearly flouting your ruling to say that we need to focus on that issue. We have a very esteemed witness here, and we are now spending our time debating a point of order. I ask you to call her to order and bring her back to the terms of reference and to direct her question. It was requiring a clarification. Come on, Natalie.
I beg your pardon. I'm happy to address them. I'm entitled to ask questions, and I think people would like to know.
Right,
and we are here to deal with the integrity and efficacy. If I can deal with the point of order.
I've heard on the point of order.
The terms of reference deal with the integrity and efficacy of public institutions. This is a public institution which has released the Premier's private mobile number, and they're asking us to have faith in their integrity. I'd like to understand about the processes, and I can confine it to, I can move on from that, and I can confine it to the processes
About to rule on the point of order. I'll ask you to finish. There's no point of order at the moment. I regard the question as having been put. Again, the Chief Commissioner is welcome to respond or take this on notice or not respond at all, and then we'll be moving on in light of the limited time that we've got to examine the terms of reference of the inquiry. Chief Commissioner.
The matter that's been raised falls within the ambit of the current public inquiry. Any events touching or concerning the Commission in relation to the public inquiry are subject to both public scrutiny but also our internal processes. And in relation to, I think, the matter that's been raised, all I can indicate is that I have directed that internal investigation be undertaken, which is being undertaken.
All right, can I ask just about the policy?
I just want to ask about the process. I'll finish on this point. If any issue like that will be dealt with following internal investigation in the public forum. I'm not prepared accordingly to preempt the Commission's processes, which are currently being activated and dealt with.
Right,
So the
thank you
release
for
of
that answer.
information that should have been redacted was not,
I'll
and
ask
we
the
are being
member
asked to have
I've indicated to the
integrity,
member that we're moving
belief in.
on.
All right, can I just ask one more question?
No, you're not welcome to. We can come back to this issue, but I'm
This
keeping a
is here,
list.
we'd like to know.
And I'm calling Mr David Shoebridge.
It's outrageous.
Thanks, Mr. Chair. Thank you, Chief Commissioner, for your opening today. Am I coming across clearly enough?
Thank you, loud and clear.
We had some evidence from the Chief Executive Officer of the Office of Local Government, Mr Hurst, about a tied grants funding round for local councils, which was some $252 million in extent. And when we were inquiring as to what, if any, notification had been given to councils who might be eligible, we were advised by Mr Hurst that his reading of the guidelines were that only once a council was identified and a project was funded did they become eligible, and therefore only once the funding was provided to that council were they notified that they were eligible, and that was the basis of the notification process. Have you, in your inquiry work, heard of a notification process like that, where you only become advised that you're eligible once a decision has been made to provide you with funding?
I can say no, I haven't. But I add that though the Commission has been engaged over the years with matters touching or concerning grant funding, I personally haven't been involved in any matter that has thrown up the issue you've raised. In other words, I've not encountered in my experience what the scenario you've outlined.
What would you say to a notification process for a funding pool, and in this case it's a funding pool which has $252 million of public funding in it? What would you say to a notification process where potential councils that were potentially able to access that funding, and in this case it was open to any council that had been the subject of a potential merger proposal? What would you say to a notification process which only kicks in once somebody in government has identified a project in that council as eligible and approved for funding? Do you have any observations about that kind of notification process?
Bridge, I'm anxious to provide as much information to this committee as I can. I am concerned that a matter such as you've raised may have already been notified to the Commission, or may in the future be required by us to consider and deal with it. So I really can't comment on the matter you've raised, other than to say this, that the guidelines normally provide for a open process, a fair process, and that complies with probity principles, as I've already stated. It would be open to a public organisation to try and, as it were, limit the likely field who will then become eligible to apply. But when I say open to it, it would still raise very serious questions as to fairness, as to the objectivity of a selection process. All of those matters would need to be considered to see whether, in effect, it's a process that is being driven by an improper purpose to obtain a certain outcome, rather than a merit-based process. I'm afraid I can't take it much further than that.
No, I understand you're answering in the general rather than
yes.
to the specific
That is a general
program,
statement, yes, a general statement, not tied to any particular matter that might be in the public domain at the moment.
Could I ask you then, on a sort of general proposition, not dealing with any one program, how important is it that public funding is allocated in accordance with signed off and transparent guidelines? How important is that, complying with guidelines that have been adopted? Is that one of the integrity tests?
It is. It's related to the questions of integrity, in my view. It is essential, I think, firstly for criteria for selection or eligibility, firstly, and then selection, to be defined with some precision or specificity. In fairness, both to those who may apply, but also in terms of a more general public interest. So,
if there is a... Oh, sorry, Commissioner.
No,
Chief Commissioner,
yes, I think I've said essentially what I wanted to say.
For example, if guidelines have not been finalised, if there's a process under which guidelines go through to get finalised, it may have multiple ministerial sign-offs. If that process is in train and before that the guidelines have been finalised, if projects were identified and approved for funding before the guidelines had been finalised, would that raise integrity concerns?
Potentially it would, because if there's a lack of a required development of a set of guidelines for a scheme, it obviously leaves the door ajar for corruption. That is, it's a corruption risk scenario. It means that, firstly, there's a lack of objectivity and fairness in the process, but secondly, in terms of determining whether it was a merit-based outcome, it becomes more difficult to discern whether there has been a departure from principles that inform the exercise of public power. In other words, the more specific the criteria are, the more that benefits the applicants to know exactly what it is that the targets they've got to meet to be eligible. And at the other end of the process, at the selection process, all the more important is it to be able to, for example, an Auditor General, to review what happened, to determine whether or not the criteria were adhered to. But if the criteria are deficient, inadequately phrased and so on, then it becomes more difficult to determine whether there has been a departure or perhaps just mere inadvertence in processing the result.
Would you expect, as a sort of basic fundamental, that there would be some kind of clear identified merit assessment of individual projects that would then be put in front of a decision maker for formal approval? That merit assessment process, that documented merit assessment process, do you think that's a non-negotiable element in the allocation of public money through grants programs?
Certainly in accordance with proper practice and principle is, as I say, critical.
All right. Thanks, Chief Commissioner. That's all I had for the moment.
Thank you, Mr. Chair.
Just while we're on that point, I might ask about two other aspects of the grant approval process, because you've drawn our attention to the Good Practice Guide for grants. We've been asked about the assessment. I might just secondly ask about a recommendation to a decision maker. Again, that's fundamental to the grant decision-making process, that there's some recommendation that sits in front of a decision maker from which they can then make their decision with whatever discretion they're permitted under the grant system. Would you agree with that?
I think a recommendation made for selection should be a recommendation with reasons. Secondly, at the next stage, the acceptance of the recommendation by the panel should similarly be supported by written reasons. In other words, accountability, transparency from start to finish.
And I'll turn to the actual decision itself. Again, you would, looking at that Good Practice Guide, it's essential that there is a record of the decision, a record of an approval, perhaps signed and dated by the decision maker would be the expectation in government. That's fundamental to the process.
Yes, I would agree, Chair. The committee would be aware, of course, of the report by the Australian National Audit Office. That's a very detailed report, and it does contain, I should say, many observations along the line that you're raising. And there is, I say with respect, much good work in that report addressing both probity, transparency and accountability issues, such as the ones you've raised.
And finally, were those things lacking? Were either a written recommendation in front of a decision maker not present, or there was no record, no signed, dated record of the decision? Those things would be of great concern. Yes. Would you agree with that?
Yes. As I've earlier indicated, what the Commission would be looking for if it were called upon to examine such a matter is firstly to establish precisely what are the conventional or prescribed processes, and identifying at any one point whether there's been compliance or diversion or non-adherence. If the process hasn't been followed, our next question would be, why not? What's the explanation? Often it can be a sign of irregularity, and that irregularity could, depending upon those involved or who have played a role, what their intention or purpose was in not complying, or their explanation for not complying.
Well, Courtney Hughes-Huss.
Thank you, Mr. Chair, and can I thank you very much for your time this morning, and also for your very informative submission to the inquiry. I think I wanted to come back to something that you touched on your opening statement around the good guidelines. And you mentioned just then the Australian National Audit Office has undertaken quite a few recent and very informative inquiries. Do you think it's time to update those guidelines, given that they have been in place for over 10 years?
I think those guidelines should be reviewed in order to determine whether they can be improved and brought up to what is now regarded as best practice. And I would regard best practice as reflected in many of the observations in the Auditor General's report to which I've referred. I think it was quite a number of years ago since those guidelines were settled, as you would be aware, and I think there's water under the bridge since then. Experience in life often indicates that it's time for reviewing it, if only to ensure that the guidelines are adequate and do meet best practice.
And so is it in your opinion that they don't meet best practice?
I can't make that judgment. I think they do address the headline issues of transparency, objectivity, fairness, merit-based processes and fairness. I think they flag and address the right issues. Whether or not, however, as matters of practice and procedure under those subheadings, the guidelines are up to scratch, as it were, up to standard, effective enough, I really haven't set about the task of trying to determine whether that's the case or not. But the matter you've raised with respect, it does warrant, I think, serious consideration. It seems that grant funding is becoming more common in the community and is important to community groups, particularly in regional areas and the like. I think members of the community deserve nothing less than having a best practice in place. Yes.
But things have moved on. I just have one more question on the guidelines. There are DPC guidelines. In your opinion, who is responsible for ensuring that those guidelines are applied? Is that the role of DPC? Do they apply to all departments? Can you just provide us some clarity with that? Is it up to ministers to be enforcing these as well?
Often, as I understand it, it is for the minister's responsibility to ensure that the process was followed. But I can't be absolutely emphatic that that's the only check. But it does raise another issue, if I might address that, is in that, yes, a department can prescribe the procedures, but there is a place, I think, for some independent input into what is the system, what are the processes, what are the criteria and guidelines that should be applied, so that it is not just simply a departmental set of guidelines. I think there should be some input from an independent agency. I have in mind, for example, the Auditor General, although she may not be happy for me to mention that because her workload is already so heavy. But an independent office such as that, I think, would give, again, coming back to trust and confidence of the community, a level of confidence that this is not just a government-sponsored scheme, a set of rules and criteria, but that it has had input from an independent agency. I think the actuality of doing that would probably to improve the guidelines. The perception would certainly be very positive, that confidence in those guidelines would be enhanced.
I'll call Honourable Natalie Ward.
Thank you, Chair. Thank you, Commissioner. I just wanted to turn to the same issue about best practice and confidence in guidelines and ask you on that. What policies and procedures did the ICAC have in place regarding confidential information of witnesses and how is it protecting that confidential information, specifically in relation to redaction of information, and will you make those policies available to this committee?
I think, are you coming back to the topic area that was you raised before?
No, I'm dealing with best practice and guidelines. I'm not dealing with anything specific other than confidence in the ICAC and its guidelines and processes.
What organisation? I might ask.
I beg your pardon?
I'm not sure what organisation or scheme you're referring to.
In the ICAC, what policies and procedures do you have in place to ensure confidential information, that is, best practice processes, to ensure confidential information is protected, specifically in relation to redaction?
If that's seen to be within the terms of reference of this.
Chief Commissioner, you're welcome to either take. It is a question about policy. I haven't had a.
People just want to know.
David Shoebridge.
I'm going to.
Yep.
And my point covers both this question, but it also relates to the prior question that was raised by that. As I understand it, I haven't seen it. ICAC made a non-publication order about both the information that was released and any content of the information that was released. And in questioning from the Honourable Natalie Ward, I assume inadvertently, as I understand it, the Honourable Natalie Ward has released details of what was in that confidential
It's in the public record.
Well, there's a point of order. I'll call you to order. There is a point of order being taken. You're not entitled to interrupt.
Yeah, released details of what was in that confidential information in breach of the ICAC order. Now, I'm not saying that ICAC order would prevent those matters being considered in this committee, but it is a matter we should take into account and hear the observations of ICAC from in due course about that release of information on the transcript. And I would just ask that you invite the Chief Commissioner, if he wishes to urgently on notice, provide any representations to us if we may wish to make any order in relation to that, the content of the information as released by the Honourable Natalie Ward. I think we owe the Commission that
Point of order?
Given my understanding of the nature of the order was.
Right, Ms Ward on the point of order.
To the point of order, Chair, there's quite a different proposition to the question, but nonetheless, the terms of reference for this inquiry specifically refer to measures necessary to ensure the integrity of grant schemes and public confidence in the allocation of public money. My questions are going directly to the issues of public confidence in the allocation of public money. That is, can the public be confident that the ICAC is using its funds to conduct public examinations fairly and professionally? I asked about processes. It would be ironic if the Public Accountability Committee rules out questions with respect to the accountability of a public body. If you're ruling out of order public accountability questions about this body.
David, no, Mr Shoebridge, wait. I've got Ms Hustos on the point of order. David Shoebridge on the point. I'm about to rule those.
I'm going to keep this really brief because, I mean, I think we're running out of time. This is a very important witness.
Take them on notice.
These are important issues that Ms Ward is raising, but they are not within the terms of reference. ICAC does not receive government grants, does not administer a government grants program, and although confidence in the ICAC is important, I would welcome terms of reference if Ms Ward wants to put those forward, but they are not directly relevant to government grants.
Mr Shoebridge.
Well, the reason I raise the point on now is that it's some reflection about the content of the material disclosed by Ms Ward in earlier questions. And I'm concerned that the Chief Commissioner may be required to go back over that material, which may well be in breach of a non-publication order made by ICAC. I say again that non-publication order would not of itself prevent this committee from investigating that, but it's a matter we should clearly have in mind and consider before we allow a line of questioning to go or before we publish the transcript. And I think the Chief Commissioner should be entitled to respond to that either now or with whatever urgency the ICAC thinks is appropriate on notice.
I've got Mr Khan on the point of order.
I think David may have made the concession which I would have sought. That is, David and I have sat obviously on a number of inquiries. The privilege of this parliament to deal with matters has been concluded to be quite wide. Statutory secrecy, for instance, does not prohibit a line of inquiry by us, and we saw that in Prospect, seen it in others, including with the Auditor General. I think he doesn't. I think now he doesn't put the matter as high as I thought he was. So I simply note that the point that David makes may be relevant to an issue of the exercise, but certainly the making of that non-publication order is not effective on this line of questioning.
All right, Ms Ward on the point of order, and then I'll rule.
Chair, I press the question. It is in my submission within the terms of reference. And I have outlined why it's in the terms of reference, because the terms specifically relate and reference to public confidence in the allocation of public money. It doesn't confine itself to grants, it's public money. My question was in relation to processes. It was in relation, the witness is welcome to take it on notice if we're pressed for time, but it was about the policies and procedures and
you've made these points a number of times. I'm preparing to rule.
Have confidence in, and I won't be threatened by members. I think we're entitled and the public wants to know what we can have confidence in and what we can't.
All right. There's two issues here. Firstly is the question within the terms of reference of the committee. I've ruled on this previously, and I'll deal with it in a similar way, which is the Commissioner's entitled to respond in any way he chooses of his own volition, although the member is drifting outside the terms of reference of the inquiry. Secondly, on the question about the non-publication order, it obviously does interact in a complex way with parliamentary privilege. I will deal with it in the way that the member suggests, which is to invite the Chief Commissioner on notice to provide any reflections that he would like to the committee, and any other decisions about this will be dealt with in confidential committee proceedings relating to the transcript. Chief Commissioner, is there anything you want to say to respond to that lengthy interaction, noting the time?
Yes, thank you, Chair. Firstly, so far as the terms of reference are concerned, it's plain from the terms of reference what the ambit of this inquiry is. And not for me to say whether it's within or without the terms of reference, the question raised. However, it would appear to me, with respect, that there's a very powerful reason to say that the questions are not within the terms of reference. That said, I previously said, and I'll repeat, that any matters concerning the Commission and its processes relevant to the current public inquiry are matters that will be dealt with by the Commission, that I have given an instruction for there to be an internal investigation carried out today. In fact, it's already, had already commenced yesterday, so that I'm in a position during the course of the day to determine what should be done. I've indicated that ultimately, once that inquiry has been completed, it will be dealt with in the public forum. And that is essentially a matter for the Assistant Commissioner, McColl, who's presiding. But my view is that it would, in the ordinary course of events, be a matter that will be addressed publicly in the public inquiry.
Will you provide those policies to this committee? Will you provide those policies?
I'll call Ms
publicly?
Ward. I'll ask you not to proceed in the way you are. Chief Commissioner, we have reached time on this particular session. Thank you for your attendance. Thank you for your submission, which is very helpful in guiding the committee's work in this area. You have not taken any questions or notice in this instance, although members may have subsequent questions, and the Secretariat will be in contact if that is the case. Thank you for your time.
Any questions on notice? Thank you.
Sorry, Mr. Chair. Before the Chief Commissioner goes, there is that unresolved issue of the potential breach of...
It's all public, David. It's all public. I won't be threatened by you. It is all public, and we have a right to know.
Ms Ward, can you come to order, please? You're entitled to make a point, but you'll do so through the chair. Sorry, you are correct, Mr Shoebridge. So, Chief Commissioner, you have been invited on notice to provide any guidance to the committee in its considerations about how these proceedings interact with your non-publication order.
Thank you.
Noting that. Thank you for your time.
Through you, Chair, just noting that those issues are public.
I thank
those breaches.
and members of the committee.
Thank you.